Yo, hold up. Before you scroll past this, I need you to actually hear me out for a second. What I'm about to put you onto is not speculation. It is not political opinion. It is not clickbait. No cap. What is going down right now, in real time, in federal courtrooms, and inside the halls of the Supreme Court of the United States is something most Americans straight up have no idea is coming. And by the end of this video, you will. Let's get it. What is good, everyone? Welcome back. If you're new here, this channel is all about breaking down the legal and political moves that actually hit different in your daily life. Your rights, your freedom, your wallet, no fluff, no spin, just the facts, straight up. And today's video, real talk. This might be the most important one I've ever recorded. There's a phrase going absolutely wild right now across social media. 10 gun laws struck down overnight. Maybe you've seen it trending. Maybe your homie sent it to you. And your first instinct was, bro, is this even real? Here's the honest answer. While there wasn't one single night where exactly 10 laws got wiped off the books, that framing is low-key capturing something very real. The pace at which long-standing gun control measures are getting dismantled right now, in 2026, is unlike anything this country has seen since the Second Amendment was ratified. Like, this is not a drill, fam. And the reason it's moving this fast comes down to one absolutely seismic legal ruling from a few years back that most people either forgot about or never fully understood. That ruling changed the whole game, permanently. So today, we're going to cover all of it. The Supreme Court emergency permit hearing. The DOJ's jaw-dropping reversal that had everyone shook. The D.C. magazine ban that just got cooked, the federal drug user gun ban now on life support, and the massive wave of legal challenges targeting some of the most controversial gun laws in American history. This is going to be a long one, no cap. Go grab yourself a drink, hit that subscribe button real quick, and let's get into it. All right. So before we get into all the wild stuff going down right now, we got to go back to 2022, because if you don't understand what happened then, none of this makes sense. In June of 2022, the United States Supreme Court dropped a ruling in a case called New York State Rifle and Pistol Association versus Bruen. And fam, if you care about your Second Amendment rights at all, whether you ride for them hard or you're skeptical, this is the most important legal case of the last 50 years. No debate. Before Bruen, here's how courts were deciding whether a gun law was constitutional. They used something called a means-end balancing test. Basically, a court would look at a gun law, ask, does this serve an important government interest? And if a judge decided, yeah, sure, it's for public safety, boom, law upheld. That's it. Easy W for the government every single time. The problem? That approach basically let judges do whatever they felt like. If a judge personally believed gun control was the move, they could almost always cook up a reason to uphold a restriction. The standard was so squishy, it was basically mid. It meant almost nothing. Then Bruen dropped, and bruh, it changed everything. In a landmark 6-3 decision, the Supreme Court threw the whole old framework in the trash. Justice Clarence Thomas, writing for the majority, said, here's the new rule, and it hits hard. A gun law is only constitutional if it matches a historical tradition of firearm regulation in America at the time the Second Amendment was ratified. Read that again. For real. A gun law is only constitutional if you can find a real historical tradition going all the way back to the founding era. If you can't show it existed back then, it's presumptively unconstitutional. This is called the historical tradition test. And it completely flipped the script on how gun laws get challenged in court. Under the old rules, the government basically had home court advantage. Under Bruen's new rules, the government has to prove its law has deep historical roots, or it loses. Period. That's a massive, massive shift. And here's the kicker, y'all. A ton of modern gun laws, the ones cooked up in the 20th century, have zero historical equivalent because those restrictions straight up didn't exist in early America. The founders weren't out here telling citizens they could only load 10 rounds. That's why everything is popping off so fast right now. Bruen didn't just change one law. It handed lawyers a constitutional crowbar, and they are going absolutely crazy, prying open every major gun restriction in the country. The dominoes started falling in 2022. By 2026, they are falling faster than ever, and we're just getting started. 8. Now we get to the story that's got every Second Amendment lawyer in the country watching their phone like it owes them money. For decades, y'all, if you wanted to carry a firearm for self-defense outside your home, you had to go beg the government for permission first. We're talking about a permit system. And depending on what state you're in, getting that permit is an absolute nightmare. Like, it is genuinely cooked. Let me paint you a picture of what this looks like in a state like California or New York. Because for folks out there living in these states, this hits different. You submit an application. You pay a fee, sometimes $200, $300, even more once you add everything up. Then you wait, and wait some more. Maybe you finally get an appointment, weeks later. Then you got to complete a mandatory training course that runs another few $100s. Fingerprints submitted, background investigation launched. And after all of that, after months of jumping through hoops, you might get a rejection letter with a vague explanation and basically no real way to appeal it. That's the reality for millions of law-abiding Americans, fam. People with spotless records, zero criminal history, people who just want to protect themselves and their families. And the system is low-key designed to make sure they can't. Now, about 2 years ago, a coalition of Second Amendment organizations said, nah, we're done with this. They filed suit. And their argument was dead-ass simple. The Second Amendment says the right to keep and bear arms shall not be infringed. Bear means carry. If the government makes it nearly impossible to exercise that right through bureaucratic nonsense, that is, by definition, an infringement. They also hit him with an analogy that nobody could really clap back at. You don't need a government permit to exercise your First Amendment right to speak freely. You don't need a license to practice your religion. So why is the Second Amendment being treated like a second-class right, where you gotta basically beg for permission just to exercise it? That's sus, bro. That's genuinely sus. That argument worked its way through the courts. And then, in a move that had everyone shook, the Supreme Court agreed to hear it on an expedited basis. For the people who don't know what that means, the Supreme Court gets thousands of petitions every year. They typically only pick about 60 to 80 cases. When they fast-track something, it means they think it's urgent enough to skip the line. That almost never happens. The fact that it's happening here, that's a massive tell. The justices aren't playing around. During oral arguments just a few weeks ago, the vibe in that room was electric. Multiple justices across the board were absolutely grilling the attorneys defending the permit systems with questions they straight up couldn't answer. One exchange has been going absolutely crazy across legal forums all week. A justice leans forward and drops this question. If the whole point of these permits is public safety, then why don't criminals bother getting them? And if only law-abiding people follow permit rules, how exactly does that make anyone safer? The defense fumbled. Straight up fumbled, because there's no clean answer to that, bro. There just isn't. But here's the moment that had literally everyone in the legal world going, wait, what? The Department of Justice, under the current administration, filed an amicus brief, which is basically a document saying, here's where we stand on this. And they sided against the permit systems. Let me say that again so it actually lands. The Department of Justice of the United States told the Supreme Court that it believes modern permit requirements have become so burdensome, so financially insane, and so administratively cooked that they effectively deny ordinary, working-class Americans the ability to exercise a constitutional right. The DOJ said that. On the record. That's not low-key surprising. That's wildly surprising. Nobody had that on their bingo card. The DOJ made 3 core arguments, and they go hard. First, we already have a federal background check system, the NICS. Every gun purchased through a licensed dealer already gets screened. State permit systems are, in many cases, just redundant bureaucracy stacked on top of something that already works. It's like paying a toll twice on the same road. Makes no sense. Second, the financial cost of getting a permit in many states is basically a poll tax on a constitutional right. And that framing hits hard because in the civil rights era, states used poll taxes to disenfranchise poor Americans, especially Black Americans. The DOJ is drawing a direct line, making someone drop hundreds of dollars and wait months before they can exercise a constitutional right. Same energy, same discriminatory effect on working-class people who can't afford it. Third, the patchwork of 50 different state permit systems makes traveling across state lines a legal minefield. A law-abiding gun owner with a valid permit in their home state can accidentally become a criminal the moment they cross into the next state. That is absolutely wild when you think about it. Americans shouldn't have to be lawyers just to not accidentally break the law while driving through another state. And if the DOJ's position wasn't already unhinged enough, 4 states that currently run their own permit systems filed briefs basically saying, we'd rather have one clear national standard than this mess. Even permit states are saying the current situation is an L. The ruling is expected within 60 to 90 days. When it drops, and it will drop, it could instantly affect gun laws in California, New York, New Jersey, Massachusetts, Illinois, Hawaii, and every other state with heavy permit requirements. No cap. This might be the most consequential Second Amendment ruling since Heller in 2008, and that was already massive. While the permit case is still cooking in the Supreme Court, other courts aren't waiting around. They're putting in work. On March 5th, 2026, the D.C. Court of Appeals dropped a ruling that sent shockwaves through the gun policy world. Washington, D.C.'s ban on so-called high-capacity magazines, specifically magazines holding more than 10 rounds, got struck down, cooked, gone. The court's reasoning was straight up grounded in Bruen's historical tradition framework, and it's hard to argue with. Magazines holding more than 10 rounds are not exotic or niche items. These things are common and ubiquitous. Tens of millions of them are in circulation across the country right now. The standard handgun magazine for a Glock 17 holds 17 rounds out of the factory. The AR-15, the most popular rifle in America, ships with 30-round magazines by default. That's just what these guns come with, fam. If a firearm or its components are in common use by law-abiding Americans, they get constitutional protection. That's the Heller standard, reinforced by Bruen. You can't ban the most normal standard equipment for the most popular guns in the country. That's a legal L, and the court said so. The court also found, and this is the theme you're going to keep hearing, that there's zero historical tradition of magazine capacity limits in America. The founding era had no such thing. Nobody was out here in 1791 telling colonists they could only load a certain number of musket balls. The concept didn't exist. Now, real talk, let me be clear about what this doesn't mean. This ruling applies to D.C. specifically, but similar challenges are moving through courts in California, Maryland, and other states. Those magazine bans are now looking extremely legally vulnerable. The writing is on the wall. This D.C. ruling is precedent, and in law, precedent is everything. Okay. Now we get into some territory that is genuinely controversial. And I'm going to be straight up with you here. Reasonable people have different takes on this one. We're just going to look at the facts. Federal law, specifically 18 U.S.C. Section 922G, 3, makes it a federal crime for any person who is an unlawful user of or addicted to any controlled substance to possess a firearm. Plain English, if you use illegal drugs, you are federally prohibited from owning a gun. Full stop. That law has been on the books for decades. Most people never paid attention to it. But in early March 2026, the Supreme Court heard oral arguments in a case called U.S. v. Hamani, and the questions from the justices were giving strong signals that at least some of them think this law, as currently written, is not going to survive Bruen. Here's why it's legally messy, y'all. This law doesn't require you to be convicted of a drug crime. There's no court hearing, no individualized determination that you're dangerous. It permanently strips your Second Amendment rights purely based on your status, the fact that you use drugs. And with marijuana now legal in some form in the majority of U.S. states, you've got tens of millions of Americans who are totally legal marijuana users under state law. But technically, they're prohibited persons under federal law. That's a wild contradiction, and courts are noticing it. The government's argument, drug users present elevated public safety risks, and historically, dangerous people got disarmed. The challenger's argument, there is no founding-era tradition of disarming people based on substance use. And stripping a constitutional right from someone without a conviction, without a hearing, without any individualized finding of dangerousness, that's not just a Second Amendment problem. That's a due process problem, too. The oral arguments were tense, no joke. The justices were visibly split. But multiple justices, including some considered more moderate, were hitting the government with hard questions about whether this law's broad sweep is even defensible. A ruling here could hit millions of Americans. We'll update you the second it drops. This next one has been flying totally under the radar, but real talk, it could end up affecting more people than almost anything else we've talked about. Federal law permanently bans anyone convicted of a crime punishable by more than 1 year in prison from ever owning a firearm again. That covers all felonies, violent and nonviolent. In theory, that sounds reasonable, right? In practice, Ren, this is where it gets wild. It means someone convicted 30 years ago of writing bad checks is in the exact same legal bucket as someone convicted of armed robbery. Both of them are permanently banned from ever touching a firearm for the rest of their lives. One of those feels like a massive L for the justice system, honestly. The Third Circuit Court of Appeals recently ruled in a case called Range v's Attorney General that this permanent lifetime ban, specifically when applied to nonviolent offenders, is unconstitutional as applied to specific individuals. The court went back to the founding era and found, while early America absolutely supported disarming genuinely dangerous people, there was no broad tradition of permanently disarming people for nonviolent offenses. The founders knew the difference between a dangerous person and someone who made a nonviolent mistake. They weren't treating those situations the same way. This is going to get appealed hard. It's already moving up. The Supreme Court will almost certainly have to take it up eventually. But the direction courts are moving is becoming clear. The era of one-size-fits-all permanent gun bans for nonviolent offenders might be on borrowed time, legally speaking. Everything I've told you so far is either already decided or already sitting in the Supreme Court's hands. But there's a whole second wave of challenges building underneath the surface, and most people haven't even heard about these yet. Let me put you on. Number one, the sensitive places loophole. Even after Bruen confirmed the right to carry, States like Maryland and Hawaii went full giga-brain and passed laws designating massive swaths of public space as sensitive places where carrying is prohibited: grocery stores, public transit, parks, parking lots, basically anywhere the public can go. Critics are calling this the everywhere ban loophole. And honestly, that's a fair name for it. States technically comply with Bruen by allowing carry permits, but then they ban carrying in so many spots that the right becomes low-key meaningless in practice. You have the right to carry nowhere. Federal courts are actively reviewing these laws right now. The legal question is simple but massive. At what point does a sensitive places designation get so broad that it straight up nullifies the Second Amendment? That question is working its way toward a definitive answer, and it's going to be a W or an L for one side in a very big way. Number 2, ghost guns. The Pennsylvania Supreme Court is currently weighing whether Philadelphia's ban on 3D printed ghost guns is preempted by state law. This case taps into a much larger national debate. Can cities and municipalities pass gun laws that go beyond what their state allows? And are unserialized, home-manufactured firearms something current law can even handle? This one's still developing, but it's definitely one to watch if you're into the policy side of all this. Number 3, assault weapon bans. The big one, all right, fam. This is the one everybody's been waiting for. Multiple petitions are sitting in front of the Supreme Court right now, asking them to finally give a definitive ruling on whether bans targeting AR-15 style rifles and similar semi-automatic firearms are constitutional. The court has been low-key ducking this issue for years, kicking cases back down to lower courts without a clear ruling. But those lower courts are now split. Some circuits have upheld assault weapon bans. Others have struck them down. And when federal circuits split on a constitutional question, the Supreme Court almost always has to step in eventually. It's not a matter of if the court takes one of these cases. It's a matter of when. And when they do, the ruling is going to be absolutely massive, no matter which direction it goes. This will be one of the most talked about Supreme Court decisions in decades. Mark my words. You've sat through the law school lecture. Respect for staying with me. Now let me bring it all the way back down to earth and talk about what actually matters. What does this mean for you, specifically? If the Supreme Court strikes down permit requirements, if you're legally eligible to own a firearm, meaning you've never been convicted of a disqualifying crime, no domestic violence convictions, never been involuntarily committed to a psychiatric facility, all the federal boxes checked, then you could soon be able to carry a loaded firearm for self-defense in public without having to get a state permit first. For real, fam, that would be a massive, life-changing W for the tens of millions of Americans living in highly restrictive states. In California, New York, New Jersey, and similar states, ordinary working people, regular folks who genuinely just want to protect themselves, have been denied that right for decades. Not because they were ineligible, but because the system was built to make it basically impossible for them. That era may be ending, but here's what does not change. And this part is critical, so don't sleep on it. You still gotta be a legally eligible person to possess a firearm. No court ruling in the world changes that. If you've got disqualifying convictions, mental health adjudications, or other federal prohibitors, you cannot legally own or carry, period, full stop. Federal background checks through licensed dealers, those aren't going anywhere. Every gun purchase from a federally licensed dealer still runs through the NICS background check. That's not changing. Federal and state laws about where you can carry will still apply. Schools are off limits. Federal buildings are off limits. courthouses, airports past security, private businesses with no firearm signs posted. Those restrictions stay in place. So don't be out here thinking you can carry anywhere with zero consequences. That's not the move. Safe storage laws in your state still apply, especially if you've got kids in the home. And self-defense laws, the legal threshold for when you are actually permitted to use a firearm in defense of yourself or others, those stay exactly as they are in your state. Getting the right to carry doesn't change the responsibility of using what you're carrying. And one more thing, and I'm going to say this directly, even if permits get eliminated by court order, please do not skip training. I'm begging you. The Constitution may soon recognize your right to carry without a license. That does not mean you are automatically prepared to carry responsibly. Owning a firearm is serious. It's not a flex. It's a responsibility. Knowing how to handle it safely, store it securely, operate it under stress, and understanding when you are legally and morally permitted to use it, that knowledge is everything. That knowledge could literally save your life or someone else's. Take a safety course. Hit the range. Practice regularly. Know your local self-defense laws inside and out. The right to carry is absolutely nothing without the responsibility to carry well. That's not political. That's just real talk. All right, let me zoom out for a second and give you some real perspective on why this legal moment is genuinely historic. Like, this isn't just another news cycle. This is different. For the last 30 years, the story of gun law in America was basically a slow grind toward more restrictions. Magazine limits, waiting periods, assault weapon bans, permit requirements, red flag laws. Every tragedy brought new calls for legislation. In many states, those calls got answered. Gun rights advocates spent those decades fighting a mostly defensive battle, challenging laws in court, and mostly taking the L, because the old legal standard made it easy for courts to uphold almost anything the government threw at them. Bruen flipped the entire script. Now, for the first time in a generation, gun control advocates are on the defensive. It is their laws being challenged, their regulations being scrutinized, their historical justifications being demanded, and often found wanting. The shoe is completely on the other foot. Courts are moving faster than they have at any point in recent memory. Judges applying the Bruen standard consistently are finding over and over that the gun laws passed in the 20th century just don't have the deep historical roots the Constitution now requires. That's not bias. That's the framework the Supreme Court set. Whether you personally ride hard for more gun control or less, whether you think this is all a massive W or a massive L, you need to understand that we are in a fundamentally different legal landscape than we were just 4 years ago. And the pace of change, it is not slowing down. It is accelerating. The next 12 to 18 months will be the most consequential period for Second Amendment law in the history of this republic. That is not me hyping it up. That is just the reality on the ground. Aight, we're at the end. Let me leave you with the practical guidance I promised at the jump. Number 1, if you live in a state with strict permit requirements right now, don't sit around waiting on the courts to save you. Go through the process and get your permit. The ruling may come strong. It may come differently than expected. Until it drops, the law is the law in your state. Protect yourself by operating within it. Number 2, educate yourself. Not just on legal rights, but on firearm safety, safe storage, and self-defense law specific to where you live. This is non-negotiable. Do not skip this step. Number 3, stay plugged in. These cases move fast. Rulings can drop with very little warning. Subscribe to this channel so you get the update the moment anything breaks. Hit that bell icon. I'm serious about that one, fam. Number 4, put people on. Share this video with someone who would want to know about this. Whether they're a Second Amendment rider or just a curious person trying to figure out what's happening in the country, This information matters. Real ones share the knowledge. We are going to keep watching these cases like a hawk and bring you the clearest, most accurate breakdown every single time something drops. That's the whole mission. I want to know what y'all think. Do you believe states should be able to require permits for concealed carry? Or should any law-abiding American be free to carry without government permission? Drop your honest take in the comments. No judgment. I read every single one. Stay safe out there. Stay informed. And I'll catch you in the next one. Peace.